Hello, and welcome to our webinar tonight. Today, we are going to talk about intellectual property protection. Surprise, Singapore webinar. And we will talk about it more generally that we sometimes do in Singapore Academy, for instance. We will talk about general approach to intellectual property protection in the green value chain. It will be quite a practical guidance. I would like, first of all, to thank Emanuela Trufo, who is our speaker for today and who is going to share her insights into the topic. I would like also to thank our partners from AIPH, the International Association of Horticultural Producers, and their magazine Floriculture International for co-organizing this webinar with us, with Siopora. It's our very first joint educational event that we offer, and the goal of this event is to raise awareness towards intellectual property protection in the green value chain, in horticulture in general. I would like also to say a couple of words on behalf of Siopora and how we think, or what we think about importance of educational initiatives like this, especially if growers and breeders come together to talk about our specific topic, intellectual property protection, that we are dealing with every day. We specialize, highly specialized in this topic, and what we think about why is it important. For us, innovation is basically the mother of it all. Innovation in horticulture results in higher profits, results in higher price premiums for all in the value chain. So it also tackles a broad range of problems in the society and in horticulture in particular. And therefore, we believe that innovation has to be rewarded and its results also effectively protected. In this sense, IP is not only the domain of lawyers, and we believe that everybody who is active in horticulture have to take a minute to think about implications of these regulatory mechanisms that creates a level playing field for all the actors, rewards innovation, rewards innovative activity, but also provides certain surpluses basically for all actors. So IP and IP compliance, if you are now, today, if you're active in horticulture or any other innovation-driven business, we believe that IP and IP compliance should be also your business. So with this thought in mind, and without further ado, I would like to introduce a little bit, say a couple of words about Emanuela. She is partner in one of the firms who are Siopora member, a lawyer member of Siopora. This is Studio Legale, Jacobacci e Associati.
Yeah,
and
great.
She's active. She specializes. Emanuela specializes in all IP matters in her firm, including PBR, plant breeders' rights, intellectual property protection such as trademarks, copyright, and also licensing in this area, and also the litigation that is related to IP. I think I'm done with my introduction. I will also say a couple of words about technical issues in this webinar room, so that those who are new among you to our webinars can easily orient yourself here. It's quite easy. On your right, you have 3 different tabs. It's chat, and there you will see we've posted some information for you just in case you're experiencing any difficulties. You can click on connectivity test and see what's wrong with your connection. It's quite a good analysis tool. Just in case, if you will be still experiencing technical difficulties, just drop me an email. I will have my eyes on my mailbox, and I will try to help you as good as I can from the distance. Please ask questions. They are always welcomed. There is a special tab for this. If you click on it, you will see there are no questions just yet, but you are always, during the lecture, after the lectures, please feel free to type them. It's better to put your question in at once when it pops up in your head. So in chat, you can greet us, you can leave some other messages for other participants or for our speaker, but please ask questions there. It is quite easy for us then to follow up with them. Under people, you will see the list of people who are joining today, your colleagues from around the world. So yes, I think that's it, and we can move to our presentation. Thank you very much, Emanuela, and stage is yours.
Thank you, Anna, and of course, Thank you, Silbrand and AIPH, for having me for this event, and thank you to you all for attending this webinar. I think that we have to spend, a few words on the title of this webinar that has been jointly chosen by Silpra, AAPI, and from our firm, of course, intellectual property, green value chain, and protection. These are three different concepts which are very important for those, as Anna just said, that are interested in doing the business in the green value chain industry. First of all, we have to define even the word, the concept of intellectual property. It might be definitely, obvious that everybody knows the meaning and the importance of the intellectual property, particularly, as Anna just said, for doing business. However, I do believe that we have to define the IP rights that are involved in the green value chain industry, and therefore in the industry that have breeders as one of the main character of all the story. We are talking about PDRs, of course. The new variety is the patent related to the new varieties. They are the base of everything. But we also have, for example, trademarks. So we have another element which is strictly related to the economic exploitation of the PDRs and all the research, investment that breeders, deployed through the years. Intellectual property is essentially the right granted by the law, no matter if you're talking about the domestic law or the international law. For example, when we're talking about CP, I mean PDRs, we immediately are thinking to UCOV Convention, for example, or the for the community regulation for the CPDO to the CPDO and to all the CP regulations. But also, what is really important is that this is the right granted by the law to prevent other people or third parties from using your own rights without your own prior consent. This is a very important principle which should be borne in mind, bear in mind when we are, when we are going to discuss contracts, when we are going to discuss the legal tools to exploit, economically speaking, for doing business the PDRs and the IP rights in general speaking regarding the new varieties. Then we have green value chain. Well, uh, properly speaking, a green value chain is a multi-stakeholder partnerships. The green value chain, of course, this definition has been conceived by FAO for the agricultural world, for the agricultural industry. But it could be referred to all the horticulture. Um, Horticulture in general is a multi-stakeholder partnership industry. I mean, it's the best example ever of what we are now get used to calling as defining as circular economy. This is what we are referring when we are talking about green value chain, and with no doubt, the stakeholders, including the value chain, are breeders, are nurseries, growers, the marketers, and of course the distribution with all the differences that we can have in distribution, and in also consumers. Let me say that we will see better later on when we are when we are going to discuss contracts, we really need to think global but act local, because no matter if we have international conventions, if we have European, communitarian regulations, directives, whatever, we don't have, for example, a harmonized and unique contract law throughout the European Union. And of course, we have specific contract laws in each country throughout the world. Um, Contract law has a direct impact on your business model and on the way and the chance you have to do business using IP rights, including PD rights, for doing business. Of course, also the market structure of each country is important and has a direct impact on your business model and on the typology and kind of contracts you may choose. You have to choose. Let me say that depending on the basics, I mean the fact that you have medium size, small sizes, or big companies working in the industry, you will have to choose to opt for one contract instead of another. You can have mature market, as for instance, we can say that, for example, the Netherlands, the Dutch market is different markets, because I'm referring to both agriculture and floriculture markets are very mature, they are very developed. Of course, the Italian market is quite developed, well developed for the floriculture aspect, a little bit less developed for the agricultural one, but each country is different. So in order to choose the proper business model and the proper way to protect your IP rights, is definitely important to choose to know properly your own market. Then, when here we are, uh, when we decide to do business uh, using PDRs and developing PDRs, well, we have to bear in mind uh, a few concepts which are very important. Well, why we are using PDRs? Very quickly, when a great summary has been provided us by Anna, when you say, well, agriculture, horticulture is a technology and innovation driven industry. Innovation regarding technology, regarding new varieties, regarding techniques to be deployed in the industry, in the manufacturing process, in developing new varieties. So PDRs are you are everybody. I mean, for horticulture, are developing PDRs and are using PDRs in their business, because, in one word, this is the only business possible. Only thanks to PDRs and the proper use of PDRs in the industry, we can have a long-term sustainable industry. Of course, we are referring to both agriculture and floriculture. When we have to define who, we have to spend a few words regarding the relationship between, the legal relationship between PDRs, IPRs in general, and the other legal principle governing any kind of legal system. As I said before, an IP right is the right granted by the law to prevent third parties from using your own IP rights uh, without your prior consent. We have in the domestic legislation, as well as in international treaties and conventions, we have a list of a set of limited exception to this principle, which means that we have set of exceptions under which the IP owner, the IP right holder, must be forced to grant authorizations for the exploitation of the IP rights, of his own IP rights. But generally speaking, the IP right holder, including breeders, when we are dealing with PDRs, are free to choose their own business partner. This might be obvious, but it is not so obvious. If we think, for example, that there are a lot of dispute, including, of course, litigation. I mean, cases brought to court. Okay, when the different stakeholders of the green value chain, as we just seen, definitely they try to put under discussion this basic principle. Uh, Being authorized to be granted the freedom of choice means that, of course, nobody can force a breeder to grant a license for the propagation of his own PD rights. And at the same time, that breeder can choose their own business partner um, to which they can authorize also the use of their own trademarks. I'm talking about trademarks and not the use of the name of the variety. As you surely know, the trademark, to be a valid and enforceable trademark, must match with a list of legal requirements, including the distinctive power. And by definition, the generic name or definition of a product mustn't enjoy this requirement. Therefore, the name of the variety, which is definitely the generic name of the of what kind of product, this specific variety, mustn't be registered as valid and enforceable trademark, not even by the breeder and by nobody else. So what is really important is that the breeder is really free, because this freedom, again, is granted by the law, to choose the business partner to whom he decided to authorize the propagation. This means the exploitation of the patent, of the period rights, and not necessarily he has to grant the exploitation, the economic exploitation, the use of the commercial brand that is registered as a trademark and is used by the breeder for offering for sale, for commercializing his own variety. So this is also important because it also underlines the fact that, in a way of speaking, IP rights are a legal exception to the general rules of competition. An IP right is, at the end of the day, a monopoly, legal monopoly granted by the law. As Anna said in helping with this webinar, the efforts, which means the investments, the time and money that breeders put into force, into action, in order to put on the table, in order to reach the goal to develop a PDR, a new variety, must be rewarded. So the PDR is the award, the award of the breeders for the research work that has been carried on through the years. The concept is the same if we are talking about patents, because let me say that our horticulture is also a patent-driven industry. I'm not only talking about PDRs, but definitely any kind of technology, including high-tech patents, that are very important for a modern horticulture. And also for patent, the concept is the same. The inventor is awarded and rewarded by lawmakers with the patent because, well, the entire IP or IP right, I mean IP system, legal system, is balanced between the interest of the society to reach an improvement, to improve from a cultural, scientific, and technological viewpoint, and the need to reward and award the inventor, I mean breeders, and all those entrepreneurs and scientists and and in a sense, really entrepreneurs that are doing research in order to get positive outcome results that can be used for a period only by themselves and then by the whole society, by the whole stakeholders. This is quite important because, of course, also when we have to evaluate the compliance of the business model of green value chain green business model with the antitrust rules, for example, we have to bear in mind that we are talking about a substantially, an IP-driven market, IP-driven business model, IP-driven industry. There we go. Then, well, what, as I said before, the base of any kind of a business model, I mean, horticultural business model, green value chain business model, is based on PDRs and other IP rights, patents sometimes, but also trademarks. And the best, best legal tools that we have to properly develop a business model for green value chain for our horticultural industry is, of course, drafting properly your contracts. Well, let me say that IP rights have a legal, a territorial scope. Even your PV rights are limited to a specific geographical area that could be the European Union or simply a member state if you decide to file your application with the domestic national office. Of course, everybody is waiting for news from the Brexit negotiation. Are waiting we are waiting for news about the destiny of the European IP rights, PDIs, of course, but also trademarks, patents, whatever, after Brexit has been delivered. They are very likely to become national, British title. So British PDRs, British IP rights, in generally speaking. Therefore, this will be very good for priority rights, of course. However, we will see later on in the transition period what kind of attitude British courts will take with other issues, like, for example, the lapse for lack of use, if we are talking about trademarks. What will be the attitude of courts and of the national offices regarding the pending application for both, priority rights and other minor aspects. We will see. Of course, the best choice ever is to have an agreement between the two parties. Without an agreement, there might be like a nightmare, but so we have to cross our finger and really see what is going to happen. Again, bear in mind that we have to think global, that we have to act local. Because, as we said before, we don't have a normalized legislation. I mean, we don't have a unique contract law. And according to the international treaties and convention regarding contracts, including, bear in mind, all the directives, approved by the European Union, beg your pardon, through the years, let me say that we don't have, we have, no matter what kind of legislation the parties decide to choose to govern their own contract, there are those that are defined the mandatory rules to comply with. And unfortunately, in each legal system, we don't have, a bill telling us that please bear in mind that the mandatory rules to comply with, no matter what kind of legislation you choose, are this, this, and this. Of course, we are talking about the basic principles of each legal system, and you know uh, essentially we have to look to study the case law, because in Italy is the most important court regarding this kind of the element, is the Suprema Corte di Cassazione, which is a sort of high court, and the function is very, very close to the European Court of Justice. So therefore, we have to bear in mind that even the concept of mandatory rules is not static, but is really, we can say, living, part of an always evolving and mutating part of our legal system, of entire legal system, but of any legal system of the world. So you have really to carry out a sort of stress test to check if your contract is complying with the mandatory rules. And let me say that it would be really useful and really advisable to check this sort of stress test, periodically. I don't say, well, every year, but let me say that really periodically you have to get in touch with your local council to say, okay, there's something new. We have to check if our draft, if our contract is still, okay, in full compliance with mandatory rules. Also, time frame is important, because, as you know, we have an application, uh, and then we have the granting of the title of the real IP rights. Well, we will spend few words regarding the Niger Court case later on, but let me say that no matter if we are at the very beginning of the story, I mean, if you are um, starting our business immediately after the filing of application, or immediately after the granting of the PDR, let me say that contract is the only way that you have to protect your PD rights, starting from the very beginning. I mean, from the date of your application um, on, I mean, till the end of the duration. As I said before, the IP rights are sort of legal monopoly. And for this reason, in trying to get the balance between the interests of the society and of the IP right holder, the lawmakers decide to fix a duration, a legal duration of your rights. After that date, your invention can be used by all the society to make this world, in a sense, a better one. So we have been talking about contracts. We have been talking about business model. But let me say that maybe I should have used the plural: contracts, markets, business models, because actually there is not only one solution, one answer to all questions. First of all, each breeder, each entrepreneur that decide to develop a business in the green value chain industry, it has to choose the target markets. Therefore, the first thing you have to do is to choose the countries or the community of countries, has the European community, where you would like to develop your own business model, your own business. Once you decided you choose the target markets, then you have to, and so you gathered all the information regarding the structure of the specific target markets you are chosen, then you have to decide your business model, or also business models, because you can also decide, and it might be the right choice, at least in my viewpoint, to have a different business model according to the markets you are facing. Of course, bearing in mind that the economic structure of each market has a direct impact on the opportunities you have to open and develop that specific market. And on the other hand, bear in mind the legal system in the legal framework, to be more precise, you are working in. Then, once you decide the business model or the business models, depending on what kind of approach you choose to have, then you can choose the legal structure, which means the contracts that must be put, into force, and it should be negotiated. Let me say that um, in the major cases, you have different kind of contracts that you have to negotiate and conclude with different stakeholders. You are very likely to need a license agreement to be cut with nurseries, and also another kind of agreement, one authorization agreement that have to be concluded with the growers, and another ones with marketers, if any. But in the 99% of cases, you have to choose the also the legislation which is more suitable to grant you proper enforcement, not only of your IP rights, of course also IP rights, but particularly of your contractual rights according to your particular business model. And the first step that you have to comply with in order to develop a horticulture, business, is to file your application. Uh, there are, yeah, very often, than the expected, uh, entrepreneurs, also breeders, are very focused on their research work, on their work in developing their own business model, that they simply forget to file the application to properly protect their own new variety or their own trademark, or at least any kind of IP rights that can be related to the green value chain industry. As we said, so we can now later on spend a few words regarding Nigel. The first step to get a protection is filing your variety. So as soon as you feel comfortable that your variety is, matching the legal requirements set by the law, please go ahead and file the application. Then, immediately after, if you decide to start your economic exploitation, your business, based on the PVR's pending application, this could be done, but you have to immediately enter into specific contracts with nurseries and with all the other stakeholders being part of the green value chain in order to give you the chance to protect your PV rights, also in that particular limbo, which is the between the filing date and the granting date. But what is sure is that without a PDR, without application, there will be no PDR. And with no PDR, you won't be able to carry on to develop a proper business. Sometimes we have the impression that, the wrong impression, that when we are discussing rules, when we are discussing PDRs, IP rights, we are discussing something theoretical, something that is, as Anna said before, the exclusive domain of the exclusive kingdom of lawyers, of judges. No, not at all. IP rights are intangible assets, and PDRs, being IP rights, they are intangible assets of the green value chain undertakings. Therefore, they must be properly protected to be the proper and useful base for business in the horticultural industries. Then again, as I said, the only way we have to protect, to get a sort of full protection of our IP rights, including in the uh, in the period between the filing of the application and the granting of the patent, is drafting and, of course, concluding contracts. Contracts that are supposed to be, of course, fair contracts. They are supposed to be contracts in full compliance with the mandatory rules, in full compliance with the general principle regarding IP rights, regarding PD rights, that uh, they can give you, even if indirect, protection of your, uh, PD rights, PD right in the making. Of course, contracts are not the solution, the final solution to all the problems related the exploitation of PD rights, no matter if you're talking about the temporary period, I mean the pending application period, or after the granting of the patent. Not at all. But contract is important to for a couple of things. First of all, because uh, having a contract is broaden your chances to get the case to court, to bring the case to court, to get a decision, because you can base your attack, your court action, not only on the IP rights, so not only on the IP rules, but also on the contract rules. And sometimes it's easier to prove, the breach of the contract instead of proving the violation of an IP rights. Not only the evidence burden is different, but please let me know that let me tell that even, the damages compensation issue is definitely easier to be solved in the framework of the breach of contract legislation instead that the IP right, framework. Then having a contract is also assuring you to have, at the end of the day, someone that is clearly identified, and that will be the one to be liable. Because when we are when we are carrying on enforcement program, in order to protect PDRs, well, the first trouble, the first problem that we have to solve is to proper identify the infringer, despite all the rules regarding traceability of projects. And please believe me that no matter if there are a lot of directives and regulations, I mean EU regulation and also domestic legislation, even in the organized distribution, the rules regarding traceability, they are not complied 100%. There are a lot of mistakes. Sometimes there are really only mistakes, I mean, by accident, good faith mistakes. Other times, they are not by accident mistakes, but they are there are means that are used to cover infringements. When you have a contract, when you have a contractual relationship that can be relied on, and you can rely on to bring your case to court and therefore to enforce your IP rights, it will be definitely easier, at least to identify the liable subject. And once you have a liable subject, someone who is liable at the end of the day, this will turn to be your best friend, because of course he doesn't like to be the liable guy. So he will help you to identify all the the value chain of infringement. So all the elements, all the subjects involved in the infringement. And so I'm going to conclude my presentation in telling you that, of course, I'm available for your question. And this is one again that the only way to properly have a business using PDRs are, of course, having PDRs, having a proper protection of your brands and your commercial names, and therefore, cutting proper deal and drafting properly your contract. Thank you.
Thank you very much, Manuela. Thank you very much for this lecture. I would like now to invite our participant to ask questions if they have them. I would suggest we will give them a couple of minutes to type the questions in. Please don't forget that you can also come on stage and discuss directly with Manuela and ask her questions, so don't be shy. It is possible, just post a small note on this in chat that you would like to go on stage and talk to our speaker directly, and I will invite you. So couple of more minutes for belated questions. It's very quiet today. Okay, what is a short announcement? We will send the presentation after this webinar in a wrap-up email. There is also a possibility to watch the video. If you want it, please let me know. My email is here in chat, and you can also find it on our website, on Siupora website, siupora.org. So I think we can wrap up for tonight. And of course, there is always a possibility to ask questions. Emanuela kindly agreed to answer your questions in writing. So if you think about something else later in the day or next week, please feel free to contact us and to ask your questions or comment on issues that were raised today. Okay, it's still Still no questions. So I would suggest that we finish the webinar right now. Emanuela, thank you very, very much for your contribution. It's been a pleasure working with you on this webinar, and I hope we will work in the future again. And please don't forget about us, about our webinars next year. Siopora Academy is coming for sure, and we will publish new programs very soon. So please check our website on siopora/academy.org for schedules next year. Thank you very much. Have a great holidays, and yeah, have a good day. Have a good night.
Okay.
Bye-bye.
Bye. Bye-bye.